Well, good afternoon, everyone. I think we'll get started. I know a few more people are still coming into the room. It's an absolute pleasure today to be moderating this event to mark the launch of 2 reports on SLAPPs in Europe. My name is Charlie Holt, and I lead Greenpeace International's work on SLAPP resilience. For those who don't know, SLAPP stands for Strategic Lawsuits Against Public Participation, and are a form of abusive lawsuit filed with the purpose of shutting down acts of public participation, including public interest reporting, peaceful protest, and other efforts to hold the powerful to account. The 2 reports that are launched today highlight the sheer scale of the SLAPP problem in Europe. The first of these reports is launched by Article 19 and is based on in-depth research on SLAPPs against journalists in 11 countries in Europe. The report highlights patterns from case studies, including those laws and legal provisions which are most commonly abused for the purposes of SLAPPs. The second is launched by the Daphne Caruana Galizia Foundation on behalf of the Coalition Against SLAPPs in Europe. Okay.
So there's a lot directly you don't want to hear about it.
Hi, sorry, could people put it on mute? I was going to say this before, but please put it on mute when you're not talking. Thanks all. Sorry. The second report is launched, as I said, by Daphne Caruana Galizia Foundation on behalf of CASE. This report is the end product of a research project that was launched almost 3 years ago in conjunction with Amsterdam Law Clinics, part of the law faculty of the University of Amsterdam. The report includes input from across the CASE coalition, and with 570 cases, represents the most comprehensive analysis yet of European SLAPPs. Together, these 2 reports show the full scale of the SLAPP problem in Europe. This then begs the question, what is Europe going to do about it? Next month, we are expecting an answer to this question from the European Commission. And we are very fortunate today to hear directly from Vera Jourová, the Vice President of the European Commission for Values and Transparency. We are also incredibly fortunate today to hear from 2 people who will be able to speak personally as to the impact of SLAPPs on their work. Catherine Belton is a journalist and author of the excellent Putin's People. I can recommend it myself here, which I now believe is the best-selling non-fiction paperback book in the UK, and it really is as good as they say. In response to this book, Catherine Belton has had 5 lawsuits filed against her by Russian oligarchs and by the Russian state-controlled oil and gas company Rosneft. Secondly, we'll be hearing from Veronika Feicht, who is a campaigner with the Munich Environmental Institute, whose campaigns against pesticide led to a large-scale SLAPP against the activist Karl Barr. Since then, the Institute has been deeply involved in the fight against SLAPPs, and Veronika now sits as a member of the CASE steering committee. Before we start, I have a few logistical points just to go. The first one I've already mentioned, but it is really important. Please do keep yourselves on mute. Only unmute when it's your turn to speak. The last thing we want is for attention to be accidentally drawn to a sniffly nose or a bad cough. So please do keep that on mute. Secondly, there will be a chance at the end of the presentations for questions. But if any questions pops up in your head, please do write them down in the chat function at the bottom of the screen. We will be keeping a close eye on those questions as the event progresses. I understand we're also live via Facebook, so hello Facebook, and please do feel free to join the discussion as well. You can write your questions on the comment function, and these will then be relayed via this Zoom room to this event here. So with all that said, I will now shut myself up and pass over to our keynote speaker, Vera Jourová, the Vice President of the European Commission for Values and Transparency. Vera, over to you, and thank you very much.
Thank you, Charlie. Good afternoon, everybody. Thank you for inviting me to speak at this event and also allowing me to listen, especially to the concrete cases of SLAPPs, which are important for us to hear because we are tailoring, as you know, the legislation on the real cases and on the situation in real life. I will probably make a trouble in organization, but I will have to leave in 60 minutes. I can't be with you all the time because we really have a hectic time. This event was planned before the war. I would never believe I will say such a sentence, but now we are in new circumstances, and also I think that it's appropriate to mention now the situation of the journalists in Ukraine, the brave people who are giving us objective pictures and information from the battlefield. Journalists, if in Russia, there are still some, you would not believe that, but many fled to EU because they cannot stand being in the country where there is no slightest space for free journalism. And we are talking about how to help to win the war. And how to help to win the war also means to protect those who now desperately need protection. And I heard this morning the statistics that shocking statistics that every 1 second, one Ukrainian refugee child is crossing the border in Poland or Slovakia or Romania. So I had to tell you this because our thoughts are now with Ukrainian people, and we are inventing ideas and channels and actions, how to help, how to isolate Putin financially, politically, diplomatically, how to in fact starve out the sources which are financing this barbaric war, and how to help those who are fighting also for our freedom and our values. So sorry, I had to start with this, and I'm sure that this is discussion to be continued because too much is at stake now for the journalists. And I don't remember such moment in my life, and I have had a long life up to now. I was born in 1964, and I don't remember the moment when we so desperately needed journalists to do their job. So thank you all who are working also under difficult conditions now. Coming back to SLAP, I want to confirm that the determination on the side of the Commission is in place. We will propose the legislation at the end of April. In the meantime, we are still collecting information, inspiration, cases, and I have to emphasize that the two reports that you are launching today are incredibly valuable source of information for us about the concrete SLAP cases. Because if you remember, 2 years ago, we started with the mapping, and suddenly we saw a very diverging picture that different situations in different member states, different traps for the journalists and human rights defenders in the concrete member state judiciary system. And so having these reports also make us understand better the scope of the issue, but also the concrete ways how the SLAP is used against the people and entities we want to protect. We don't only have the abuse of legal proceedings or the judiciary system. We also see increasing threats to the journalists' physical and online safety, and so this goes together as creating very unfriendly, hostile, very difficult conditions for the work of the journalists. That's why I am only mentioning that we launched the process based on our recommendation on the safety of journalists. We launched the process of bilateral discussions with the member states on what else should be done to protect the journalists better. I spoke 2 weeks ago with all the ministers of culture, whose job is not to protect the journalists against the threats, be it online or in real life, but they promised me to give the proper messages also to their colleagues who are responsible for the security of the people. And coming back to SLAP, at the beginning of February, the CE coalition handed over to me a petition against SLAPP signed by 200,000 people. Impressive number, impressive effort. At that event, I heard from journalists who were targeted because of their reporting on organized crime, from activists who were targeted for organizing support for victims of LGBT hatred or anti-LGBT hatred, or for doing environmental advocacy and campaign work. And I have to say, the stories really stuck with me, and it was a very, very strong push also for me to keep the track and continue working on both legislative and non-legislative measures, which I promised. We intensified our preparatory work. We collected data, studied many cases, discussed with experts and stakeholders, with our member states. We opened a public consultation so that citizens and stakeholders can share their views on SLAPPs and anti-SLAPP measures in a structured way, and a dedicated consultation targeted to national judges, because judges play a key role. We will have some obligations for them or some procedural conditions for them to act in order to avoid the abuse of justice, if I can simplify that. We concluded that the most efficient way to prevent and fight against SLAPP would be a solid combination of legislative and non-legislative measures at EU level. In line with the Commission's competencies under the treaties, we will therefore propose a directive laying out targeted procedural safeguards against SLAPP in cross-border civil proceedings. And we are at the same time aware that many SLAPP cases occur in domestic context and do not necessarily have cross-border implications. And that's why we are also going to issue the recommendation. I would like to engage with the UK representatives, because now UK is the third country where in the past were a lot of these strategic lawsuits held, and so we will also use the possibility of addressing it bilaterally. The fact that online media content is accessible across jurisdictions opens the way for forum shopping or libel tourism. This amplifies the problem for targets, exhausting their resources, adding linguistic barriers, and driving up legal costs even further. And the effect is even stronger when journalists or right defenders are sued outside the European Union, which is exactly the case of the, for instance, United Kingdom. And I'm sure that Mrs. Belton will give us today an indication of how much such lawsuits can cost in London, and how the prospect of paying damages risks to completely ruin financially individual journalists and even wipe out of business their media or publishing houses. The testimony of Mrs. Belton will be very important for me for the case. I will have some bilateral discussions from my side. In preparing the directive, we have been looking into effective ways to protect EU targets from SLAPPs brought against them in third country jurisdictions. The directive will be complemented and reinforced by non-legislative measures. I mentioned the recommendation, which is soft law or softer measure than directive, but also we want to cover other aspects, awareness raising, training for journalists, rights defenders and judges, support for targets, as well as a better system of monitoring SLAPP cases in the EU. This initiative is planned for the spring, the end of April. As I said at the beginning, we will propose the directive plus the non-legislative measures all together in one package. So I look forward to engaging with you also when the initiative will be out. as we will need the joint efforts of EU institutions, member states and civil society to make sure that its implementation will make a difference for journalists and right defenders on the ground. I had a useful discussion with the Ministers of Justice. I think it was in December, so some time ago. And I can tell you the reactions were very variable, or they differed one from each other. And the strongest concern which I heard from the ministers was that there might be some privileged group of people who will have an automatic easy ticket to favorable decisions of the courts, while others will have more difficult access to justice. So I confirm that we will come with a proposal or mechanism or system which will keep untouched the access to justice for everybody, but which will address the toxic thing, which is the abusive nature of those litigations, which should be discovered as soon as possible by the judges, and which would enable judges to dismiss the case or to finish it without prolonging the procedure for months or years ahead. To conclude, we are also now working on the Media Freedom Act, which safeguard media freedom in the EU. So while the anti-SLAPP is more focusing on the protection of individuals, the Media Freedom Act is focusing on the system and on the standards for media freedom and independence and pluralism in the EU. So that's the difference. We will have to consult and convince a lot of very key entities and individuals, because I already hear voices that there is no space for the EU to legislate on media. I don't agree with this opinion. So I have in mind that I forgot something important, but maybe it will come back to me when you have the discussion. And of course, you will inspire me also for other things maybe to say. But again, Charlie, are you okay with my leaving a little bit after 3? Yeah?
Yes, absolutely. Thank you so much. I really appreciate that. I will just say, with that in mind, that if anyone has any questions for Vera Jourová, please do put them into the chat function as soon as possible. And actually, with that, we do have one question already, and that is, which is in the chat now, which is that you've said that some reluctance from ministers for justice to this initiative. So the question is, has this changed with the war in Ukraine?
Honestly, everything has changed with the war in Ukraine. We are changing. If concretely the position of the member states on the anti-SLAPP has changed, I cannot tell you, because I have not had a chance to discuss with them after the day of invasion. But my guess is that more than before the war, we will realize, or we will have to take action to protect the journalists better and stronger. I think that this will be, it's horrible to say it, because the war does not serve to any good, any benefit. Yeah, but the war also serves as an eye-opening moment for many, on many issues. And you know that we have the media situation covered in our rule of law annual report. So whatever we do to protect media and protect the journalists, we do it for the sake of stronger democracy in the EU. And what we see in Russia, it's an incredible case, or illustration of the fact that when somebody has absolute power, which is not limited by institutions and constitutions, then it leads to absolute evil. And one of the institutions which should work in the society is media. It's the media sector. It's journalists. So I believe that it could have positive impact on the willingness of the member states to move on that. We have one issue when preparing the legislation now, and this was the beetle in my brain, which I forgot to say. We draft legislation where everything has to be absolutely clearly defined. Because when you have legislation which imposes obligations on some bodies or individuals, you have to be very precise. And we are circulating around the definition of who is the journalist, who is the human rights defenders, or who are the people who should enjoy this kind of, if I may say, privilege. And so if you can help me, maybe I will have to read your reports. I have to honestly admit I didn't read them yet, because really this is so hectic time that we work on other things. But if you can help me with this, it will be very appreciated, because we don't have any definition anywhere. Who is the journalist?
Thank you so much. There's one further question here, which is whether whistleblowers are included in the definition. That's from Anna at the Whistleblowers International Network. And she said she'd be very happy to help in the definition phase on that.
This question is just increasing my frustration that we have not yet come to a conclusion how to define those who should be protected by this anti-SLAPP legislation. And of course, working on that proposal, I always realize, wait a minute, this is very similar to what we did in the legislation to protect the whistleblowers in European Union. And here also we didn't define so clearly who are the whistleblowers, but the definition was more about the public interest. So I cannot exclude at this moment, if we go for the way of defining properly the public interest, that those who write the articles or take actions, they are not doing it for their own profit, but for the public, then we might come to opening the space also for the whistleblowers in case if they will fulfill the criteria of doing something in public interest. But this is one of the channels of my thinking, or the directions of my thinking. How to speak long and not to give an answer, this is the art of politics.
Well, thank you for that. It was very helpful. And let me just reiterate to anyone, please do, if you've got any further questions for Vera Jourová, please do add them to the chat box here. You'll be around with you until 3 p.m. CET. So any questions before then, we can make sure are asked before you leave. I would also just say I'm very grateful to you, Vera, for reminding us of the grave context in which we're operating. And I think if anyone can speak to the link between SLAPPs and Russian kleptocracy, it's our next speaker, Catherine Belton. Catherine, if I may pass over to you now to talk a little bit, it'd be great to hear from you about how SLAPPs have impacted your work over the last few years.
Hi, thanks so much for inviting me to join this session. I'm so grateful and honoured to take part in this. I think you're right, what's happening now in Ukraine really does highlight the importance of journalists being able to operate freely to investigate the operations of the Putin regime, whether that be in Russia or in the UK or elsewhere in Europe. I mean, there may have been blind spots in the ways that some of the UK media have covered his influence operations in the UK, for instance, due to the chilling effect of the threat of libel suits. And I think my cases, they're quite well known by now, but they're the tip of a very big iceberg, because I think there are lots of UK media which up till this point have regularly censored themselves the minute they've received a threatening legal letter from deep-pocketed billionaires, whether they be Russian or otherwise. I think it's really highlighted the importance of public interest journalism. So I wrote the book Putin's People. It came out in April 2020, and nearly a year after publication, we first of all faced a surprising announcement from Roman Abramovich, the billionaire owner of Chelsea Football Club, that he was going to sue us, me and my publisher HarperCollins, for defamation. He was outraged that we dared to say that he was close to Vladimir Putin, and the suggestion in my book that according to 3 close former associates, he had purchased Chelsea Football Club on the orders of Vladimir Putin. The book had always contained a denial from a person close to him. We'd put these questions to his spokesperson, and you know, the book had also said, well, whatever the truth of the matter, we didn't know whether it was true or not, it still became a symbol of the Russian cash that was flooding into London. So this was something that we believed was carefully written, and yet we still faced this attack, and it became an unprecedented attack, because shortly after Abramovich made that statement declaring he was suing us for defamation, several other Russian billionaires joined in filing suits against us. First, there was Mikhail Friedman, Piotr Aven of Alpha Group. Then we received a letter of complaint pretty much the same day from Alisher Usmanov, another Kremlin-linked billionaire. I must note that all these 4 now have since been sanctioned by the EU and the UK and the US. And then shortly afterwards, we also learned that the Kremlin oil giant Rosneft had also filed suit, though it was a blank claim, and we didn't even know about it until the FT made inquiries at the UK High Court. So we had no idea what it was about. And so we were facing a kind of a real problem, because, you know, this was an unprecedented amount of claims. My editor, Arabella Pike, she wrote to me saying, this looks like a concerted attack against you and the book. We were trying to figure out what had caused it. We didn't know whether it was a coincidence or not, because 2 months before, Alexei Navalny, the Russian opposition leader, had quoted from my book in his video about Putin's palace on the Black Sea. He had, you know, he waved it in the air. It may have been that this had brought the book to the Kremlin's attention in a way that it hadn't before. We don't know. Is it a coincidence that all these cases seem to come then? But it was certainly a concerted, seemed like a concerted effort to discredit the book. You know, so this, I did, from my publisher's point of view, I didn't know whether we would be able to fight all these cases at the same time, particularly when it's so costly to defend any case in the UK. And the cases really serve to highlight, in my mind, that sort of no matter how you know how great the public interest, how well sourced the reporting is, it's still more or less kind of beyond the means of any media or organization to mount a public interest defense. We first of all applied for a preliminary hearing on the meaning of the passages these oligarchs were complaining of, because in the Abramovich case, for instance, and the Friedman case and the Rosneft case, they were applying meanings which saying that the book meant things which we hadn't even said. They were exaggerating the meanings to make it seem as though we'd said the worst things possible. So we had kind of, to some degree, way, we were lucky in that Friedman and Arvin didn't want to pursue the cases. They didn't really have an appetite for pursuing them all the way through the court. So we were able to reach an accommodation with them. But that involved me removing 3 phrases from the book surrounding Friedman's alleged involvement with and backing from progressive elements of the KGB in the late 80s when he was starting out in business. These were, again, matters of public interest. There was a former government official who was prepared to testify. Had the case gone to trial, he would have gone on the record. And we had other reporting, public interest reporting, backing this up. It was well sourced, but we felt that because we were facing so many claims and it was so expensive to fight them all at once, that it was strategically better to agree to remove 3 phrases from the book which made no difference to the narrative whatsoever, and that it could be still understood from the context, so that we could remove 2 cases from 3 that we were still having to fight. So we got rid of them. In the meantime, Abramovich had raised the pressure even further. He filed the exact same claim against my publishers in Australia, which was a clear attempt to intimidate HarperCollins out of defending the book. It would have more than doubled the costs of defending it. Australia is a particularly tricky jurisdiction for libel claims, because at the time he filed it, there was no public interest defense, only truth. So our lawyers knew that we were going to face a tough battle, but again, they filed in the Australian court for the judge to dismiss it as an abusive process, and we clearly considered that it was. Abramovich had no business interest in Australia, so therefore no reputation to protect, and HarperCollins didn't even publish the book in Australia, so it was clearly a move at intimidation. Nevertheless, our lawyers at the preliminary hearing were able to get Mr. Abramovich's most exaggerated claim thrown out of court. He tried to say that the book had alleged that he had a corrupt relationship with Vladimir Putin and that he was making payments into Kremlin slush funds. The book didn't say that, and the judge took our side in that case, and she said what the book had said was that he was under the control of Vladimir Putin, and this was going to be something that was much more difficult for Abramovich to dispute, given all the reporting in the book and everything that we know about how the Kremlin operates. So shortly after that ruling, we received a settlement offer from him in which we managed to keep all the main claims that he attacked in the book intact. We softened the language and gave more space for him to deny. And with Rosneft, the Kremlin oil champion, that its claim was so preposterous, it was almost a relief. They sent a huge letter trying to claim that we defamed it for saying that it participated in the expropriation of Yukos, the one-time #1 oil major in Russia belonging to Mikhail Khodorkovsky. There is a lot of international litigation already pointing to Rosneft's clear involvement in this. It's been something that's been aired thousands of times in international media. So it was a completely ridiculous case. And indeed, the judge threw 3 of Rosneft's claims out of court, saying they weren't defamatory of the company, that it was a put-up job, that the claim should not be being fronted by a state oil giant in the way that it was. So we managed to get rid of that, and the case with Abramovich was settled to some degree satisfactorily. But along the way, we did have to remove some phrases that I was upset about removing, such as one quote from a close associate saying he is Putin's representative. And we agreed to remove it because of the sheer cost of continuing to fight the claim. So already fighting 5 cases in the UK last year cost my publisher HarperCollins £1.5 million. And had we not agreed with Abramovich, had we not agreed to soften the language. Even though we had a strong public interest case, we'd had all the responses from his spokesperson accurately recorded in the book. Had we not agreed to make these slight amendments and remove a few extraneous quotes here and there, such as this one about him being Putin's representative, which is now clear he is, especially since from the language of the UK sanctions, we would have had to continue to fight the case on public interest grounds. It would have cost my publisher £2.5 million in the UK and more than that again in Australia. And it's too weighty a procedure. It's so time consuming. It already consumed 9 months of the year from the moment Abramovich made his announcement. I couldn't do any other journalism apart from defend the book against those cases. It cost so much money, and had we continued to fight the Abramovich case on public interest grounds, it would have taken and consumed another year, perhaps more, just because the procedures, although there is now a public interest defense, the procedures involved in maintaining the public interest defense are so cumbersome, so bureaucratic. You have to hand over all your devices for disclosure proceedings. The billionaires can drag out those proceedings to make it cost the publishers even more. That, you know, it's like the system is stacked against you from the start, and really you don't stand a chance. I mean, I was very lucky in that my publishers stood by me, but I think it's certainly the case that many UK media organisations, because of the huge cost in defending any such claim, basically agree to censor themselves rather than have to get involved in such a lengthy and costly process. And I think that's all I need to say.
Thank you so much, Caruana. That was really helpful and insightful. I very much appreciate your time today. If anyone does have any questions for Caruana, please do add them to the chat. We will get to these questions at the end. We will ask further questions. I see some have already added questions to Vera Jourová before she leaves at 3 p.m. Before then, though, I do want to hand over to Veronika. Veronika, I think you're there now, and it'd be great to hear from you, Veronika, about how SLAPPs have impacted the work of your organization.
Yes, thank you, Charlie. First of all, thanks so much for inviting me, and especially thank you to the Daphne Caruana Galizia Foundation and to Article 19 for the fantastic research that went into your report and for organizing this event today. So I'm very grateful as well to Vice President Jourová for being here today and taking the time to listen to our testimonies. You already mentioned the event in Brussels in February, when you accepted over 200,000 signatures from people across Europe asking the Commission to come forward with an ambitious anti-SLAPP EU directive. Maybe you also remember that we met there briefly. And the reason I was there that day and that my organization became a member of the Case Coalition in the first place is that I work as an agricultural policy campaigner with a small German NGO that is called Umweltinstitut München. So that's the Munich Environmental Institute. And it is our work on agriculture which got us into the situation of being targeted by a SLAPP lawsuit. So what led to this is the fact that as part of our mission to promote a pesticide-free agriculture, we decided to support the fight of a small community in South Tyrol in the north of Italy against the high use of pesticides in apple cultivation in this area. So when this little village called Mals set to become Europe's first pesticide-free municipality, we saw this as quite a miracle, and recognizing the significance of this pioneering work is what made us launch a small campaign called Pestizid Tirol, so that's Pesticide Tyrol, with the objective of making the German public aware of this discussion on pesticides going on in a region that is very popular among Germans for tourism. And the response of this region's government was unfortunately not to engage us in an open debate about the local growing practices and their impact on human health and the environment, but to file a lawsuit against us. So what happened is that Arnold Schuler, the agricultural minister of this region, he filed criminal charges against the board of directors of my organization and against a former colleague of mine who was the one in charge of the campaign at the time. He is not here to give his testimony himself today because he's actually been recently elected to the German National Parliament and stopped working with my organization for now, which is why I'm the one telling you the story, as I was very involved in this process as well. So the accusation was that our Pesticid Tirol campaign amounted to harmful defamation of the South Tyrolean agriculture and the province itself. And in addition, we were also being accused of brand infringement upon the region's umbrella brand because we created a satirical pesticide Tyrol logo that was based on the official brand of this region during our campaign. So this politician, Arnold Schuler, convinced over 1,370 farmers from this region to join his criminal complaint. And this, in our scenario, the sheer number of plaintiffs is what made the slap so threatening to us. Because in case of conviction, all of these farmers would have been able to demand compensatory damages from us. And that could have amounted to millions of euros and financially ruined the organization. So what followed is that we had to allocate massive amounts of our resources as a small organization. So that means time, money, and energy towards our defense. Of course, at the core of this was the time that we had to invest into finding a team of lawyers that would be able to defend us in a foreign jurisdiction, but also collaborate with us in German, in our native language, and the time we spent on working out our legal strategy to defend ourselves in court, as well as the burden of having to cover hundreds of thousands of euros of legal costs, which is a huge amount of money for a small NGO. But because we decided to not only fight this legal battle, but to also make this attack on freedom of expression public, what came with it was the time and money spent on preparing countless press releases, in German, in Italian, and in English, on setting up a multilingual press conference, on staging a protest outside the court building on the day that the criminal trial began, on coordinating interviews, posting on social media, and building up a network of organizations from across Europe standing in solidarity with us. So in the months and weeks leading up to this day in September 2020, when the criminal trial started, there was hardly a member of our team, that's not that big, who was not at least partially involved in all of this work. And of course, that meant that we were kept from doing our normal work. So in the end, all of this effort did pay off because we were able to create enough public pressure to make the plaintiffs withdraw their complaints. However, because of the number of plaintiffs, this was not something that just happened easily overnight, because the collection of all the signatures by all the farmers that were necessary for the complete withdrawal, that just took months. So this was a time during which we still had to keep up the public pressure, as well as, just like spend hours and hours in Zoom meetings, strategizing with our lawyers and planning our next steps. Finally, in January of 2022, so this year, all of the 1,376 complaints were indeed withdrawn. But unfortunately, it's still not over for us, because brand infringement under Italian law is actually an ex officio crime, which has to be prosecuted by the public attorney, regardless of the initial plaintiff's withdrawal. So this goes to show that a slap can open a sort of Pandora's box that's hard to close, even if the ones behind the legal attack eventually come to realize the error of their ways, so to speak. So in order to avoid these sort of Pandora's boxes from being open at all and tangling up NGOs like us in lawsuits for years, we think that it is very important for the accused in these scenarios to have the possibility to report to the responsible judge the suspicion that the lawsuit might be abusive. And should this suspicion prove to be true, request for an early dismissal of the case. Additionally, we consider it urgently necessary to introduce the possibility of penalizing notorious slappers in order to deter them and others who might follow their example from abusing the law in this manner. And here what I'm talking about is really like hard financial penalties, because in our opinion, this is the only measure that would really tip the scales and put those who like to use slaps to silence critical voices in a position of actually standing to lose something. So of course, the case coalition in our model EU directive against slaps has introduced a catalog of effective measures, but these two are the ones that I would like to emphasize today, speaking from our experience being targeted by a slap. Yeah, thank you for your attention.
Thank you so much, Veronika. And once again, if anyone does have any questions for Veronika, please do add it to the chat function. We will be getting to those at the end of these presentations. Before that, though, I want to go back to Vera Jourová. We have another question for the Commissioner, and this is in relation to Daphne Caruana Galizia Foundation. We'll be hearing later on from the Daphne Caruana Galizia Foundation, who have worked tirelessly on this issue over the last few years. The question here is about the murder of Daphne Caruana Galizia Foundation in 2017 and the influence this had on the current proposals. So Vera, if I may just go back to you on this, to what extent did the murder of Daphne Caruana Galizia contribute to this proposal? And did it have any influence on the willingness of member states to move forward on the issue?
Yeah, in fact, this anti-slap law should be named Daphne's law, yeah, because her case and the horrifying fact that at the moment of her assassination, her family inherited more than 40 cases. It is such a shocking, the fact this is possible, the fact that this is such an efficient instrument, especially when used abroad, and the scope, the number, it was such a shocking picture or a situation that I have to say it helped me to convince many that we need to take action. And so I sometimes say that Daphne is, even several years after being murdered, doing a great job for the journalists in the EU. She's still with us, she's working, and her story is really helping. It's very compelling story for those who hesitate. And I have to say that I use this example as the opening information also with the Ministers of Justice several weeks ago. There is also a question about the citizenship by investment programs. Charlie, I don't want to take your job if you want to ask me the question.
Please do go ahead.
Okay, yes, because here I have a rather good news in all that miserable war situation. Malta, after a long time, decided to stop, to close the shop with the passports for Russians and Belarusians. They did it on the 2nd of March, so 1 week after invasion. On the other hand, this is a systemic bad thing, yeah, that we have the citizenship for those who have money. So we have to continue also the work against this principle, but we don't have we only have at this moment I think only 2 countries which are continuing some kind of passport selling.
Thank you so much. I'm conscious of the fact that you need to leave at the hour, and I'm very keen that the 2 reports are able to be presented before that. So I'm going to move over now to the reports and the presentation of those reports. And I'm going to start with Article 19. So Sarah Clarke, I believe you're here to present on behalf of Article 19 and the report that is being published today.
Thanks very much, Charlie, and thanks to everyone who's here today, many of whom have been very involved in all of the research and these reports and in the wider work of CASE, which is the Coalition Against Slaps in Europe. So our report, which we're launching today, is looking at the situation of slaps against journalists in 11 countries across Europe. So we have so we've Belgium, Bulgaria, Croatia, France, Hungary, Ireland, Italy, Malta, Poland, Slovenia, and very importantly, the UK. We chose these 11 countries within the EU, the 10 within the EU, because they're countries in which we had seen notable reports of slaps against journalists. And then the inclusion of the UK was essential to understanding the EU context, because without the UK, we can't understand the issue of cross-border cases, which we go into in some detail. And these are cases taken against journalists and others who are not resident in the UK, but they're litigated out of the UK courts. And I'll come back to that, but it's a really kind of crucial piece of the puzzle to solving slaps. And to why it's so important that we're also really keeping an eye on what's going on in the UK, which Catherine has illustrated. We worked with lawyers in each of the 11 countries. So we had country researchers. Each of them were practicing lawyers who were well-versed in law and practice in their countries. And they followed a standardized research template to identify the laws and procedural characteristics that are exploited by claimants in slap cases. While this research isn't exhaustive, but when you look at this with the CASE report that's launched today as well with the Daphne Caruana Galizia Foundation, you can see just how wide an issue this has become. And we really welcome further in-depth research because it's only really been in the researching and monitoring of these cases that the extent of slaps in Europe is coming to light. And we've really only been looking at this in a concerted way since the assassination of Daphne in October 2017. So it's kind of the last 4.5 years where we've seen kind of a burgeoning both of the research and mapping, but also all of the advocacy that you've seen in Brussels that has resulted now in these measures, and also in Strasbourg, where we've recently had it confirmed that the Council of Europe will be launching a recommendation against slaps. So we've had some, huge momentum on this issue, and this is really the moment where we're pushing very strongly for this reform in Brussels, in Strasbourg, and of course in London. So just to pick out a few trends from our country studies, first, there's a clear overall trend of an escalation of slap cases in all of the countries that we surveyed. The majority of these cases are taken at the national level, not at the cross-border level. And I think that's what's really important when you look at the Commission's measures, that while they will go to the heart of the cross-border issue, a huge amount more pressure is now going to be necessary at the member state level to see comprehensive reform around slaps. So the Commission's measures are very important, but we're going to need to see that the story won't end there. We're going to have a lot more advocacy and pressure at the national level for comprehensive slap reform. What we see in general is that these cases are characterized by a severe power imbalance between the plaintiff and the defendant. All of the slap cases in this report were brought by politicians, businessmen, or corporations. And in some cases, there are very close links between these three categories. All of these plaintiffs have considerable financial resources, and bringing lawsuits is simply a cost of doing business for them, whether that business is commercial or engaging in politics. Meanwhile, the defendants in the cases are a small group of independently minded media and journalists, many of them who are defending multiple cases simultaneously, sometimes dozens of them. These cases may be won, lost, or settled, but the aim of the process is to financially and otherwise drain them and stop their critical reporting. Media and journalists rarely, if ever, recover their full costs, let alone the time and other resources invested in defending the case. And you can really hear that from Veronika and Catherine, that the sheer time and money drain that these cases bring, and that's their intention. And we've seen this, in many countries, especially Italy, Belgium, Malta, Poland, Slovakia, where you have, multiple cases taken against single defendants. And it's really, really difficult for them to ever recover the costs that they have to mount to defend themselves. What we also see, in particular, as it relates to media organizations, many in certain countries, media have to report slap claims on their balance sheets, and this could be to the tune of several million euros. And this can bar them from claiming their legal fees in full, even if they successfully win. So, for example, in Italy, where defamation demands can range into millions of euros, the defendants are required to report these amounts as potential liabilities on their balance sheets. And we see that this makes it very difficult for journalists and outlets to get insurance. And very few companies or outlets even have insurance. And where they do have it, it doesn't cover these costs. So often what we see is media and journalists are forced into settlements purely for financial reasons, even if they believe they can defend their journalism. While claimants don't always win, in fact, they rarely win, and this isn't necessarily good news for the journalists. So they don't have to win. The point is really to litigate over a period of as long as possible. So often, many years, up to 10 years, we've seen these cases go on. And so where journalists might win at the end of 10 years, it's often a Pyrrhic victory because they haven't been able to report on the investigations that are, at issue before the courts, or they're financially drained because it's not that they only pay those legal costs at the very end. That's very rare. People need to front the legal costs often up front. We see in terms of the legal actions that are used, defamation is definitely the primary law of choice, but we do see an increasing number of cases that are taken under privacy laws, such as in Belgium and the UK, and data protection. We've seen in particular in Hungary, where a lot of cases have been taken on the grounds of GDPR. It's notable that in a number of countries, many slap cases never reach the courts. Frequently, they're not even filed, but we see that the mere threat of litigation can suffice to scare a journalist, media outlet or NGO. And we see that several law firms, most notably in the UK, but also in other countries, have developed very aggressive tactics to essentially bully journalists and media outlets into self-censorship, usually on behalf of wealthy clients. And something we've always said at Case is that it's vital to name these law firms. And there's a lot of work underway on this issue in the UK. And Catherine, in her testimony yesterday, at Parliament, really was also raising this issue of the importance of naming and shaming the law firms that are involved in devising and profiting from these strategies. We talk in the report about how the process itself is the punishment. So the process of slap cases, involve lengthy, complex legal processes. They're very rarely resolved in less than a year. We see them range. The kind of average time length is about 3 years, but in many countries, these can go up to 10 years, as I mentioned. And throughout this time, defendants have to engage the services of lawyers and invest time and resources in the defense of cases that would much better be spent on their work. So even where the journalists prevail and are able to recoup some of their legal costs, it's very rare that they will finish this out of pocket. In fact, we hear many stories of journalists having to put their houses on the line or all of their savings just to defend themselves. So clearly there's a need for procedural safeguards. In particular, as been mentioned, the early dismissal of cases at the national and cross-border levels. In very few countries or jurisdictions globally, do we have any SLAPP legislation. In no European country do we have anti-SLAPP legislation at this point. We have seen a few countries come forward with proposals. So notably Malta, Ireland and Lithuania have noted that they are going to put forward anti-SLAPP laws. I think it's really important, particularly having seen the Maltese proposals, that these laws are robust and comprehensive, and that they're subject to the scrutiny of international organizations such as the Council of Europe and the OSCE, because unfortunately what we've seen to date simply hasn't met international standards and doesn't stand up and won't significantly prevent SLAPPs in countries such as Malta. So we need to see much more rigorous legislation being put forward. So we also need to see protection against cross-border cases, and that's why there's so much work going on at the moment, both in the UK, but focused on the UK from the European perspective. So we know that the vast majority of cross-border cases are taken out of London, and that journalists, in many countries now actually train themselves on English libel law, so as to understand, how to get around being sued in the UK. That's very, very difficult. So I think all of the measures that we're looking for in Europe, we need commensurate measures taken in the UK. That's why the UK anti-SLAPP group is also pushing for an anti-SLAPP law. And that's really crucial, not just for journalists in the UK, but for journalists throughout the region. Finally, as has been mentioned, SLAPPs, we see are part of an eroding climate for media freedom. And in many cases, the problem of SLAPP lawsuits come in conjunction with other threats to independent journalists, including surveillance campaigns, smear campaigns, and then, of course, verbal abuse, violence against journalists. And so we see that SLAPPs are amplifying the overall threats to journalists in the region. We have very detailed recommendations in the report, which I'd invite you to look through. But obviously at the European regional level, we're urging the Commission to put forward as ambitious and robust an anti-SLAPP directive as possible. We know the difficulties in terms of pushing for binding national measures around SLAPPs, but we do urge the Commission to go as far as possible in their work on this. But we see that the next steps are also really going to be focusing at the member state, at the national level. And some of the key issues that we really need to see is the full decriminalization of defamation in the jurisdictions that we're looking at. We see criminal defamation is still on the books in most European countries, and it's being used and abused as SLAPPs. So we'd like to see that defamation decriminalized. And then when it comes to civil cases, we need to see comprehensive safeguards in civil cases. Those are detailed in our report, but the three main issues are the early dismissal of cases, the caps on damages and penalties for plaintiffs. So those are sort of the main points from Article 19. And so I'll leave it there, but I'd really invite you to look through the report and come back to us with any questions. Thank you, Charlie.
Thank you, Sarah. I'm going to pass straight over to Corinne Vella. Vera, I see a couple more questions for Vera Jourová in the chat, but I'm going to pass over to Corinne to speak on behalf of the Daphne, Caruana, Galizia Foundation and launch the case report on SLAPPs in Europe. Thank you, Corinne.
Thanks, Charlie, and thanks for including us in this event. I have to say at the outset, the report we worked on behalf of a coalition against SLAPPs in Europe draws primarily on data which was collected by the Amsterdam law clinics. And over a period of several years, students in the law clinics were collecting data on cases and developed a methodology and a way of defining a case as a SLAPP. So we were really grateful to their input of that data, and they're sharing it with us. I'm just going to share a link in the chat to visualization of some of the data which we used in the report. That's a very handy guide to the actual content of the report, showing a distribution of cases across the 29 countries that are featured in the study, and the weighting of cases according to jurisdiction per capita, according to population, and so on. Just a few highlights. It's both disturbing and perversely reassuring to see in the data documenting something we had already known, which is that Daphne was singled out as a target. She is, in the data that was collected in this report, she was the most targeted individual out of all the 29 countries that are featured in this report. And Malta has the highest per capita number of cases. It's a disgraceful record, so it's really important to us, both on a personal level and also on a professional level, to see that there is a move towards having legislation put into place to protect journalists and other public watchdogs across Europe. That is so, so important. And everything that Sarah outlined, the early dismissal of cases, the need for support at a national and international level, the need to dismiss cases, whether they are domestic or cross-border, all of that was we could see in the findings of our report. Some of the features that we found, that I'll just highlight those to you. We've come to a stage, given a turn of events, that it's almost become redundant to explain what a slap actually is. But it is important also to point out that there is still a huge swathe of people who don't understand those. What we have found in the data, that the characteristic of slaps is that plaintiffs are not concerned with protecting their reputation or protecting their data. They are instituting cases simply to silence the defendants and the causes of those defendants represent. So this is the common factor in all the cases, which is the abuse of existing laws to intimidate and harass people who speak out, whether they're journalists, whistleblowers, activists, advocacy groups, academics, or any other kind of public watchdog. And disturbingly, you find that slap cases are filed in countries which have strong democracies, as well as countries where there are critical rule of law concerns. And that is precisely because the law is being abused to defeat its spirit. It actually, and in a strong democracy, is actually being threatened by the use of its legislation to undermine democracy itself, which is a very disturbing trend. And in a number of cases across Europe is on the rise, so that is another disturbing trend, which means that the problem is accelerating. And when you set the findings in the context of what this exercise has been able to achieve, it's that this is a scoping exercise. So the problem documented in the report is definitely greater than what we have been able to analyze. There are cases out there that we have not found. There are people out there who have not spoken up, because that is the way slaps work. They silence people and they achieve their aims in this way, sometimes simply by threatening people, not actually taking them to court. Back to the report itself, it's based on over some 570 cases. And why cases alone is because legal cases are on record. The documents concerning the case are usually available. The plaintiffs and defendants are recorded. And unlike slap threats themselves, which serve to coerce people into obedience in advance, court cases are on the public record, and you could actually talk to people who are involved in those cases and understand their experience. The data on the slaps, it only, as I said, it only presents a fragment of the reality. And the chilling effect goes beyond the defendants themselves. So for every person who's targeted by a slap, even if they fight back, there are a swathe of others who will think twice before they speak up. We know this not just from the data, we also know it through Daphne's experience. The litigation she faced, had the effect on her of eating up her time, her money, and her energy. It didn't kill her fighting spirit, but it is wearisome to fight those cases. And she recognized herself that she had been turned into what you could call a negative example. She actually spoke about that in an interview she gave a few days before she was killed. So people look at me and they think, I don't want to do this. So people within the profession are put off from covering the same stories, and people who might have considered entering the profession would think twice. And that would be true of anyone who's targeted by slaps. So I mean, just to sum up, basically, the report has documented something we already knew through Daphne's experience. And it is so important to see that there is growing interest in the field and recognition of the problem, and that there is a move at a European level to actually do something about this, which will hopefully pull in all EU member states into taking action themselves.
Thank you so much, Corinne. That was really helpful. And I'm already seeing a lot of questions in the chat, which is brilliant, and we'll hopefully get to all of those in time. But perhaps I can use or abuse my prerogative as the moderator here, just to start with a general question for all those who have spoken. And the question is, what do you think is the most important thing that needs to be covered in any legislative response to slaps? And Corinne, maybe I can start by asking you that question, just because I think it follows nicely from your presentation.
Could you repeat that, Charlie? Sorry.
Apologies. The question was,
the sound wasn't good. Yeah.
The question is, what is
Sorry,
the most?
I have to go. Sorry.
Oh, no worries.
Have a good day, and thank you. May I ask you before I leave? Do you plan to send this report to the ministers also?
Yes.
Can we plot a little bit, yeah, that we have the ministers informed, because some of them looked like never having heard of such cases. Yeah.
We'll be in touch. Yes, let's plot. Thank you.
Thank you very much. Bye. Have a good day, and thank you for what you are doing. Bye bye.
Thank you. Thank you. And so the question was, what do you think is the most important thing that any legislative response to slaps would cover?
All right, where would you begin? I would say, given that we're not trying to prevent the phenomenon from occurring, it's already there, there are people already facing slaps. I would say that early dismissal of active cases would be a huge step forward. Based on Daphne's experience, that would have made a really big difference. And that's particularly because, as Sarah explained, slaps work not by reaching a conclusion, but by being drawn out, sometimes over years. And you don't want to wait for those years to pass, where your money's locked up, your time's taken away, your attention's diverted, and your energy is sapped, and your morale is depressed, and people are put off. So the early dismissal of a case in itself will have an immediate effect on the individual, and it will have a cumulative effect across the entire, let's call it, slap industry. Because if it becomes pointless to file cases, then in the long run, there's a rate of attrition, which it doesn't pay you to file those cases, because there's a cost without the results you want to achieve. And it would sort of filter out, the totally vexatious cases.
Thank you for that. Perhaps I can ask a similar thing of Catherine Belton. In your experiences, what do you think would be most important for any type of response to cover?
I think Corinne is absolutely right. It's so important that there is a mechanism which allows these type of cases to be dismissed at an early level. We've been speaking with our main defence lawyer, Caroline Keane of Wigan, about what that might involve for the UK, and she's very much recommending that there should be a very early look for a judge about whether a case involves reporting or something else that's clearly in the public interest, and say if it was, for instance, either reporting on the influence operations of the Putin regime, or if it was about sort of the defective cladding of Grenfell Tower, or sort of medicines, or something like that, when it's very clear that there's a public interest involved, that the judge should be able to review that, and as a remedy for any claimant who feels that they haven't been properly represented, then then the media publication would grant a greater right to reply to that person. So if they've already been given a right to reply in their general reporting that led up to the publication, that they might be given the opportunity to add to that right to reply. And that's it. It can be then added by the publication into its, the publication itself, but it doesn't have to be adopted as truth. And then that's it. It's a very quick process, certainly should not cost much money. And that's one way for very, very quickly eradicating any such claim. And I certainly hope that might be reviewed.
Thank you so much. Sarah or Veronika, I just suppose you've got anything to add to that?
Yeah, I think, when we've seen successful anti-SLAPP laws in the US and Canada, they've also included a cap on damages. I think that's crucial. We see huge damages at stake across Europe and obviously in the UK. I think if we had a cap, that would limit some, but not all. So I think that would be one thing. And another is this issue of penalties. So penalties for the plaintiffs who are bringing these cases, in particular for repeat offenders. And we see repeat SLAPP offenders across the board in Europe.
Thanks, Sarah. Veronika, just to move back to you, I've seen a couple of comments here, and I'm sorry we weren't able to address them while Vera Jourová was here. There's been a couple of questions here about, in addition to whistleblowers, others who engage in active public participation, particularly activists. Now, obviously, you've been working with environmental activists and having experienced SLAPPs your own. I'm wondering if you could speak to the chilling effect that SLAPPs have on acts of, for example, peaceful protest and direct action, and other acts that activists and advocacy groups tend to engage in.
Yes, of course. So since we have experienced the SLAPP lawsuit, I'm afraid it is true that we have become more careful in a way. So every time I publish a statement or we write a press release on any issue that could be in any way construed as SLAPP worthy, we check that multiple times now, and we really had to take a conscious decision not to be less confrontational, to be less activist. So you really notice the effect that it has, like in your own head, and you have to actively step forward and say, no, I'm not going to be affected by that. And I think we are in a position of having the privilege to say that, because we are an NGO. We have a team of people who can work on defending ourselves in their paid time, but we also see other people. For example, I know a French anti-pesticide activist who is not affiliated with an organization like that, but does her work in her free time after coming home from work in evenings, and she does not have the resources we have. And I think for people like that, just individual activists who are not professionally affiliated with any organization, it's much more difficult to really take this decision and say, no, I am going to keep raising my voice no matter the consequences. And I really have in the last 2 years since we have experienced this SLAPP, experienced it myself, and also talked to a lot of other activists who've been in the same situation. And it's really mostly like something that changes in your mind, and that's I think really the most the scariest part of the phenomenon.
Thank you, Veronika. I mean, if I may pass that over to you, I've seen a very helpful comment in the chat there. So the question is about personal scope here, and about whether or not the directive or any legislative measures will cover all those who express themselves publicly, and obviously encompasses the type of activities that Veronika was talking about. And I see that Belinda also asked specifically about the LGBTI activists who Věra Jourová met at the petition handover last month. I think you might be on mute.
Yes, there are two unmute buttons here on my desk, one on the screen and one on the device that I'm using. So apologies for that. Thanks, and thanks for the questions. So I think just to dispel any doubts from the start, of course, we focus a lot the communication efforts also on journalists. It's also because, of course, the journalists are the most common targets. This is what we know. This is what you have also seen in your data collection. But of course, by far, are they the only ones? So the testimonies here from Veronika and also all the material that you have gathered show that it is not just journalists, but a series of rights defenders. And when we speak of rights defenders, of course, we have quite a broad category of activities that are covered there. And then, of course, beyond even the individual, so the individual journalist or the individual activist, we have all the structures around them. Yeah, I mean, the testimony of Catherine was quite telling, because in her case, without the support and efforts and readiness to stand in trial of the publishing house, I mean, this would have been a completely ruinous endeavor for any individual journalist. So we have the publishing houses, the media outlets, and the civil society organizations in the framework of which the people are active, that can also be targets. So we are going to try to be as comprehensive as possible. We have, of course, announced, I mean, this initiative, maybe it's good to just bring back a little bit the context. This was announced at the end of 2020 in the framework of our European Democracy Action Plan. Yeah, I heard a lot of references to how important this is for our democratic fabric. And this is exactly where we started from. And in the European Democracy Action Plan, this was, of course, included in the chapter on media freedom, but we have from the very beginning included this in the Commission work program as an initiative to protect journalists and rights defenders. And I think it's very useful to come back to something that the Vice President has said earlier in her intervention, that the most important thing here is the concept of public interest. So this is what you can expect to see in our initiative. This is what is going to be a bit the defining element for all the activities that will be protected by what we will propose. And I hope that this answers the questions.
Thank you so much. I really appreciate that. I'm going to move to the comments which have been made by us in the chat function. The first one is for Sarah and Corinne. And that is a question: if we did manage to shut down the slap industry, and this is slap industry in the UK, and the EU passes an anti-slap directive, will the problem then move outside of the EU? Is there another center of power other than the US where the slap industry might move? So, for example, in Switzerland. I don't know if anyone's got Sarah or Corinne, have you got questions?
I can just say a few points. I think the UK has been sort of uniquely good at becoming a libel hub, and that's largely because of the expense of the courts and the whole the different industries in the UK, from PR firms to reputation laundering or management and libel. So you don't have that infrastructure to that extent anywhere else. We haven't seen the Swiss courts used as a center of libel tourism. If anything, actually, the concern has been that somewhere like Dublin could become the center because of the kind of common law similarities between there and the UK. So I don't fear another centre emerging. I mean, if it does, obviously we need to work on that. But I think London is the key to solving an awful lot of this.
Thanks, Sarah. I mean, I suppose there's two other points there to unpack. The one is the extent to which an EU directive or EU measures would actually be able to address the problem of the slap industry in London, as you say, a non-EU country. And the question, of course, goes beyond the EU directive, which is that once that is passed, that doesn't, of course, address the problem fully, and slaps may emerge elsewhere. Corinne, maybe I can turn that back over to you. I don't know if you've got any thoughts about, beyond the directive, how those problems can be addressed. And of course, a lot of them are cultural.
Yeah, certainly that cultural, it's cultural within the country, but it's also culture within professions. One of the interesting things that I saw happening in the past couple of weeks, ever since the invasion of Ukraine began, is that it seems slap letters were being delivered to people in power. And that drew more attention to the problem in the UK. And surprisingly, we saw the Solicitors Regulation Authority updating its guidelines to its members as a result of this. So that points to something. The lawyers who engage in slaps themselves need to be weaned off the practice by a variety of measures. Some ethical standards need to be put into place addressing slaps explicitly, because the integrity of the profession is key to the proper functioning of the profession and the proper functioning of justice and ultimately a democracy. So I think that is key. Has it happened yet? No. Slaps are a lucrative business, particularly even in situations where you can put a cap on damages, say in a libel case. People can get around that by filing multiple suits. So you get the small amount of damage multiplied several times over. That's something that happened in Daphne's experience that's been addressed in legislation already, but that risk is always there. The one thing about the slap industry is that it's very creative about flowing around all the obstacles it finds in its path. So, it's going to be a sort of constant whack-a-mole, pushing against these problems. But I would say that it's key, one of the keys to the problem is, more integrity within the profession. And that has to be imposed by force, some sort of objective ethical standard and like some kind of mechanism within the profession that can keep people to that standard. He's starving the profession of opportunity, as it were.
Thank you so much. The next question on the thing is I think leads on quite neatly from that. It's a question about some of the positive examples that we can find across Europe of measures which have been set up to tackle slaps. Now, as Leah here says, that there are no anti-slap laws currently in place in any member states at this point. And that is, of course, true beyond any laws. There are no legal provisions which explicitly tackle slaps. But I'm wondering if anyone has any positive examples of good practices, whether that's legislative or non-legislative, across Europe that you've come across during your research, which can potentially be copied by the EU or other countries.
From our side, no, there are a few countries that have some mechanisms around early dismissal, but that are very opaque, very rarely used, and they're not, the purpose isn't to deal with slaps. So in France, for example, there are some procedures in place, but that are very rarely used, and there's a very high threshold to have a case dismissed at an early phase. So in Article 19's research, we had to look outside of Europe. We looked to a number of states in the US, California, Oregon, and others, Ontario and Canada, to look at the legislation and the measures that they've brought in. And if you look at the Case Coalition's anti-slap model directive, many of those measures are included there in our recommendations to the Commission.
Thanks, Sarah. I don't suppose anyone else has anything to add to that. If not, I realize we're getting close to the end. There's one more question on here, which is particularly interesting. It was directed to Catherine Belton, but I don't know if anyone else has any thoughts about this, which is the extent to which the increasing development of cancel culture is affecting the problem of slaps. Does anyone have any thoughts about that and about this? I said, did you make any experience in this direction as well? If anyone has any thoughts about the link between cancel culture and slaps. It's a tricky one. I think, I'm not sure if there might be any direct link before that, but of course, a climate of intense polarization is certainly something that we recognize as being problematic in this regard, in the sense that it often gives cover on people who are keen to discredit journalists and other public watchdogs. I think that might be part of it, but I don't know if others have any thoughts on that.
I think it's not directly involved, but I think just when you were saying that about some of the kind of slappers that we've seen who you wouldn't automatically think of, and this goes outside of the European context, are like, we've seen this in the context of child abuse. We've seen it with religious organizations. Scientologists are notorious for slapping. So it's not just the usual suspects. You know, we see this used by a wide variety of actors. So I don't think that necessarily fits in with the cancel culture element, but we're always kind of intrigued and surprised by the plaintiffs that we see coming up.
Thanks, Sarah. I don't know if anyone's got anything to add to that. Otherwise, it is 2:30, so I will start to close this up. I'd like to say a huge thank you to all our speakers for their time today. It's been really appreciated, and I think we've all learned a lot here. One thing I point to before we leave is that the links to the two reports are now available. You can see them at the top of this chat. I think it'd be great if we can post that down below. I'll do that myself. And please do check those reports both out. The other thing to say is that, as Vera Jourová said earlier today, we are expecting the European Commission's measures to be announced at the end of April. CASE will be responding to this soon after, so do please stay tuned for more details. We will be talking more about that via our Twitter account. I will also add this to the chat here. You can follow us on Twitter. I don't know if anyone else has the Twitter handle available to them now, but I think it is @CaseCoalition. So I'm trying to put all of this here. Please do follow us to continue finding out more about this and about other work that we're engaging in. Until then, thank you so much all for joining us, and I hope to see you all soon. Bye-bye.
Thanks, Charlie.
Thank you very much to all. Bye-bye.
Thank you. Goodbye.